Hi, thanks so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the incredible Stephen Marso, an Iowa construction lien law expert. Today's webinar topic is getting paid faster with liens, bonds, and contracts. So without further ado, I'd like to introduce the wonderful Stephen Marso.
Thanks, Jesse. Hi, everyone. My name is Steve Marso. I'm an attorney with Whitfield Netty in Des Moines, and I practice mostly in construction law. And we're going to talk about liens, bonds, and contracts, specifically how you can get paid utilizing those. And there's four main subjects I'm going to cover. One is Iowa's Mechanics Lien Statute, Iowa's Little Miller Act, the Federal Miller Act, and then some contract provisions. So quite a bit to get through, so I'm going to get started. If you do have questions, you can go into the chat box and post them there, and then after we're finished, Jesse will let me know whatever questions there are, and I'll try to answer them. So the first category is Iowa's Mechanics Lien Act. So one question is, what's the deadline to file a mechanics lien in Iowa? And the answer is 2 years and 90 days from your last date of work. So that's the deadline, obviously, to keep track of if you're going to be filing liens to get paid. Is 2 years and 90 days after your last date of work. Now, Iowa has a 90-day deadline that is important. Again, if you miss this 90-day deadline, doesn't mean you can't file a lien, but you want to try to file it within 90 days of your last date of work. And the reason for that is there's some additional requirements that you have to do if you file beyond the 90-day deadline. And one of those is you have to serve the lien on the owner if you're beyond 90 days. And second, if you do file beyond 90 days, then your lien is only good to the amount due by the owner to the GC at the time you serve that lien. So if you file within 90 days, you're not subject to any of those rules. So the key takeaway here is try to file your mechanics lien within 90 days of your last date of work. But if you're beyond 90, but you're still within the 2 years and 90-day deadline, you can still file a lien, and then you'll have to determine whether or not there's any value to your lien or not. So those are the takeaways on the deadlines to file liens. Now, what's the deadline to file a lawsuit to foreclose a lien that you've already filed? The answer is 2 years and 90 days. There's a caveat. If someone serves you, after you file a lien, serves you with a demand that you file suit within 30 days, then you have to file suit within 30 days or your lien is lost. But absent that, it's 2 years and 90 days from your last day of work. There is a notice requirement for lower tier subcontractors and suppliers who do not have a contract directly with the general contractor. And this is the statute here that addresses that. The takeaway here is the deadline to submit the notice to the general contractor is 30 days from the date of first furnishing any labor or material. So it's an upfront notice. And if you miss that notice, then you've forfeited your lien rights. So this is important for those who do not have contracts directly with the general. If you do have a contract with the general, you're a sub and your contract's directly with the general, you don't have to do this notice. But if you're below that, then you do. Now that, before I move on, that's for commercial construction only. There is a residential section of the Mechanics Lien Act. The notice requirements are much more onerous on residential projects. I'm not going to go into the details of those. I'm just going to note them here. There's a couple of notices a general contractor has to give, and then there's a couple of notices that a subcontractor has to give. The details of those are in the statutes, but just understand if you're on a residential project, a lot more notice requirements than commercial. Residential construction, I just mentioned, is defined here in the statute. Pretty typical single family or two family dwellings, which is what you'd think of as a residential home. It also includes this reference to Chapter 499B. What that is essentially apartment complexes or condominiums if they are organized under the specific statute. So if you're working on apartments or condominiums, understand you could be working on a residential project. And so it's good to contact your attorney to find out if that's the case, because if you are, then there's a lot more notice requirements you have to give. If it's not considered residential, then you're under the commercial scenario, and that's a lot easier as far as notice requirements. So just to understand apartments and condos, you need to figure out whether it's residential or commercial, so you know what notices to give. One other thing here with Mechanics Lien Act is there is a prompt pay statute. It only applies to residential projects, and it doesn't have a lot of teeth. The statute's 572.30 here in the Iowa Code. You can look at that for more details, but understand if you're on a residential project, there is this prompt payment by generals down to subs, and you can see the requirements there. And finally, attorney fees. The Iowa Mechanics Lien Act has 2 paragraphs on attorney fees. This is the first one. This applies to residential and commercial projects, so every project. It's a one-way attorney fee provision in favor of the claimant only. So if you're on a commercial job and you're defending against a mechanics lien lawsuit, you cannot get attorney fees under the statute as a defendant, even if you prevail. However, the second paragraph applies only to residential projects. That does allow an owner, essentially, if you're defending against a mechanics lien claim, an owner can recover attorney fees. So in the residential context, the attorney fee provisions in the statute are essentially prevailing party. On commercial projects, it's only a one-sided one in favor of the lien claimant. The defendant cannot get attorney fees under the statute on a commercial job. So that's the Mechanics Lien Act. I'm going to move now to the Little Miller Act, Iowa's Little Miller Act, under Chapter 573 of the Iowa Code. This governs non-federal public projects in Iowa. And there's retention, or retainage sometimes it's called. So each progress payment, the owner can hold up to 5% of the payment due to the general and hold that as retainage. That's held to essentially pay subcontractors if they're not paid. Now, legislative update this year, the legislature passed a law and the governor signed it, reducing that 5% that can be held down to a maximum of 3%. So that goes into effect July 1st. So after that date, it'll be 3% instead of 5%. Now, there are payment bond requirements on under the Little Miller Act, and any project that's equals or exceeds $25,000 has to have a performance and a payment bond. And the general contractor has to furnish that. So we're going to talk about payment bonds here. And essentially, this is the statute that says if under that payment bond, the surety is essentially guaranteeing payment to subcontractors and of lower tiers even if they're not paid. So where do you file claims if you aren't paid, you're a subcontractor and you haven't been paid? You have to file it with the project owner. You have to file a written claim. And then you'll notice in the second paragraph here, suppliers to suppliers do not have claim rights. So that's an exception. But other than that, generally the lower tier subs and suppliers can file claims. What's the deadline to file a claim? It's a little confusing under the statute, but the main default rule is no later than 30 days after completion and final acceptance of the project. That's the deadline to file a claim. There's a second paragraph you'll note there, and that's limited to those claimants who have a contract directly with the general contractor. And essentially, you can file a claim if the owner hasn't paid the full contract price yet to the general contractor and there's no lawsuit yet filed concerning those contract funds that are being held. So if those conditions are met, then you could file a claim beyond the 30 days. One caveat to this deadline I just mentioned, the 30-day deadline, is if the contractor abandons the project or is terminated, that then triggers that 30-day deadline. So understand if you have a general that's walked off or is terminated, then that claim filing deadline runs from the date of termination. Now, after a lawsuit's filed, the court does have discretion to allow a claimant to come into the lawsuit and file a late claim. There's not a lot of law on this. Seems that might be limited to those who have contracts directly with the general too, but that's not clear. So essentially the takeaway here is try to file your claims no later than 30 days after final acceptance of the project. But if you're beyond 30, and even if there's a lawsuit filed, you might be able to file those claims anyway, but you might want to consult with an attorney on that. There is a notice requirement. Similar to the mechanics lien statute we looked at earlier, this notice requirement applies only to those subs who do not have a contract directly with the general, and the notice is an upfront one. Again, 30 days from the date of first furnishing labor materials is when this notice has to go to the general contractor. And if you don't give it, if you miss that deadline up front, then you've forfeited your claim rights. What's the deadline to file a lawsuit on a claim you've already filed? It's a little unusual here. The deadline is no later than 60 days after final acceptance of the project, but you'll notice it does not allow you to file suit until after the expiration of 30 days from final acceptance. So there's kind of a 30-day window under the statute when lawsuits are allowed. You can't bring them too soon and you can't bring them too late. So that's the deadlines for that. And then attorney fees. One attorney fee provision, and it's only a one-sided in favor of the claimant. So only a claimant can get attorney fees under the statute. A general or an owner, if they defend against a claim and succeed, they cannot get attorney fees under the statute. Okay, moving to the Federal Miller Act. Governs federal construction projects. One thing different about this from compared to the Iowa Little Miller Act is there's no retainage under this statute. There's only payment bonds for subcontractors to make claims against. There is a written notice requirement. So similar to the notice requirements under Iowa's Mechanics Lien and Little Miller Act, it only applies to those who do not have contracts directly with the general contractor. It is different than those statutes, though, in that the notice runs from the end of work, not at the beginning of work. So you have to give this notice to the general no later than 90 days after the last date of work. Compare that to Iowa's Mechanics Lien and Little Miller Act, that's 30 days from the first date of furnishing. So the Federal Miller Act is not an upfront notice. Excuse me. What's the notice have to say? It's a little unclear, but essentially the notice should state the material and labor furnished to the project, who it was supplied to, and the balance owed. There's not a lot of requirements in there, but you want to make sure you have at least those basic requirements in there. Now, the notice has to go to the general contractor. There's some details on how you got to serve it and where you got to serve it, but the courts are pretty flexible on that. If the evidence shows that the general contractor received the notice from the sub, then it's probably going to be good. But you should know that there is some language about requirements, and you want to try to comply with those if you can. What's the deadline to file a lawsuit on a Federal Miller Act claim? It's no later than 1 year after the last date of work by the claimant. So you get a little more time than what the Iowa statute provides. So it's 1 year from last date of work. Okay, now we're going to turn to contracts. So I'm using the AIA as kind of the form to highlight some provisions in here to make sure you're aware of. The contract you have might have variations on this, but the first one is section 9.5.1 of the A201. And essentially what this says is the architect gets to issue and decide on certificates for payment. And one of the things you'll notice is the architect can refuse to certify in whole or in part if there's various things that they find here, defective work, for example, third-party claims, and so on. So understand that the architect has the power of the purse to a large extent under this contract. The lesson is do your best to make the architects happy. You know, if they want certain things done as required by the contract, even it seems like it's maybe technical, make sure you're following that. Excuse me, because again, they have the power to certify or not. Conditional payment clauses, there are two types, pay when paid clauses and pay if paid. Pay when paid suspends the obligation to pay. So for example, excuse me, if an owner doesn't pay a general and you have in your subcontract a pay when paid, then that only suspends the general contractor's obligation to pay the sub. Unless, for example, the reason for non-payment by the owner is because of the sub. But if that's not the reason for non-payment, then eventually the general is going to have to pay the sub even though they haven't been paid by the owner. In contracts, the pay if paid clause, it doesn't matter what the reason is or how long the delay is. If the general is not paid, then the general does not have to pay the subcontractor. So the entire risk of non-payment by the owner is transferred to the subcontractor, okay? So you need to understand that there's two different types of those conditional payment clauses. The pay if paid is the more strict against subcontractors. Now, if you're drafting these and you want to have a pay if paid clause as a general contractor, for example, then you need to make that clear. If there's ambiguity in the language, courts typically will interpret it as a pay when paid, which is more advantageous to the subcontractor. The lesson, if you are a prime contractor, you probably want to have a pay if paid if you can. Make that clear. If you're a subcontractor, you do not want a pay if paid. You want to pay when paid or not any conditional payment clause. So just understand that when you're negotiating and reviewing these contracts, that those two different types of clauses exist. Finally, under the AIA A201, there's a concept called a claim, and this is defined here. And essentially, it's, for example, someone saying they're owed additional money, for example, would be a claim. Now, one important part of this provision is that claims need to be initiated by a notice to the initial decision maker. And for example, if a claim is being made by the general contractor, it has to be, the notice has to go to the owner as well. Typically, the architect is the initial decision maker. And so if that's the case, then the notice has to go to the architect and the owner. Notice the 21-day deadline. So you want to make sure that you give your notice of claim to the architect and owner within 21 days of the event arising. Now, keep in mind, a claim is not only just it's not just for payment of money, but it can be for extra time. Both of those are claims, so you have to give your written notice for either one of them or both within this deadline, and make sure you meet that, because courts have dismissed claims if they fail to submit a timely written notice. One thing to notice in the AIA is the section 1.6.2 that says notice of claims, which we're talking about, are only deemed served if they are sent by certified or registered mail or by essentially personal delivery. I'm not a fan of that provision. I don't know if courts would enforce that and say your claim's bad if, for example, you emailed it out and they received it as opposed to certified mail. But the lesson here is comply with this if you can, with the caveat that if you don't, court might say you don't have a valid claim because you didn't certify mail it. The lesson, follow all of your contractual requirements, make sure you know what they are, meet them and the deadlines and the requirements in them. And that's all I have on that. And Jesse, if you want to let me know if there's any questions.
Yeah, no, that was incredible. Thank you so much. That was a lot of information that you just packed in there for us. So thank you so much. We do have a couple of questions that came through, and it says, the first one here is, if you don't send the preliminary notice as the sub, are there any extensions given?
So let's go back to the preliminary notice provision. Let's scroll back here. So this is under the Iowa Mechanics Lien statute. It would apply to residential projects. So the preliminary notice, there's no deadline, so to speak, for a preliminary notice. It's not like, for example, you got to file it within 10 days of something. However, under the statute, your lien is only good to the amount owed by the owner to the general contractor at the time that you file and the owner receives that preliminary notice. So the point is, the earlier the better to file those. There's not an extension, so to speak, because there's not a deadline. But just know, if you wait until the last possible moment, let's say you're owed money, you wait, and then you go ahead and file that. If the owner's paid the general by that time, then your lien is only good to the amount owed. And if the amount owed is zero, then your lien is worthless. So the lesson here I would suggest is file those earlier rather than later.
All right, good. Thank you so much for that clarification. And then Another question that came through is, after a lien has been filed, can you amend the lien to include further charges if you have continued to do more work?
Good question. The answer is no. So the statute allows you to amend your lien to reduce the amount. And that's a pretty easy process that you do on the Iowa Secretary of State's website. So in Iowa, you file your lien on the Iowa Secretary of State's website. The statute allows you to amend the lien downward in an amount through the Secretary of State's website. And the reason for that is there might be payments made on a lien, and so they wanted to make it easier to reduce the lien amount. However, if you want to increase the lien amount, or you do additional work and are owed additional money, you need to file a separate lien. The statute does not allow you to increase the lien amount. And some of the reasons for that are there's priority issues and priority rules about liens. So once you file it, they're not going to let you essentially file a kind of a placeholder lien for 10 grand and then say, okay, I'm amending this upward now by another 50 grand and I keep my priority place on the date I filed my initial lien. They don't let you do that. So essentially, if you're owed 10 grand, you file a lien, you do some more work, and you're owed another 20 grand, you're going to have to file another lien. And that's how that works.
Okay, and then you kind of already talked about it a little bit, but are there priorities given depending on who files the lien ahead of you, not just the mortgage?
Yes, so there's so the general rule is any mortgages, those types of things that are filed before the lien claimant starts their work is going to have priority over the lien. I'm not going to get into these relation backs, but the 90-day deadline I mentioned earlier, like, hey, you can file your lien within 2 years and 90 days, but you really want to file it within 90. If you file it within 90, your priority date relates back to your first date of work. If you file beyond 90, you lose that relation back, and so your priority date is the date you serve the lien on the owner. So that difference could cause others to be in front of your lien. For mechanics liens, it's among mechanics lien claimants, it's dates of filing of mechanics liens are priority deadlines among mechanics lien claimants. But typically that I run into are issues with non-mechanics liens, like mortgages and those types of things. So the relation back can be important. But among mechanics lien claimants, it's whoever files first prevails over someone who files later.
Yeah, so like you said, it's important to get those taken care of early and get them filed. All right, and then this appears to be the last question that's come through, and it touches back to something you said early on, I think, in the presentation. If you're served a notice that you must file the suit within 30 days after filing your lien, is that 30 calendar days from when you receive that letter?
Yes, it's 30 calendar days. And so this applies to not just mechanics liens, but also the Little Miller Act has a similar provision. So if you are a claimant or you file a lien and you receive one of those demands, make sure you contact your attorney to file suit within that 30 days, and it's calendar days. Now, there's a question, like, what if the calendar day falls, 30th day falls on a Saturday or Sunday? I think the general rule, and it's in the Iowa code, that it goes to the next date that the courts would be open, for example. So the next Monday, for example, it's not a holiday. But I always err on the other way. By Friday, the Friday before instead of the next Monday. I just don't like to wait until the last minute.
Well, you don't want to have to do that or have that argument if you can prevent it.
Yep, exactly.
So I completely understand. All right, that seems to be all the questions that have come through. If anyone does think of another question that wasn't addressed, please feel free to reach out and I'll be sure to answer any questions for you. And then when you can, the next slide, please.
Okay.
Perfect. All right. So here are some of SunRay's resources to help you guys stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources. It will go over all the differences between each individual states. Remember, each state has its own unique lien laws. What Steve has talked about is strictly for Iowa, so please check that out if you are working in a nearby state. There's project information sheets on there to help you guys kind of know all the parties and the entities working upstream from you, so you know what you need to do and what's required of you. And then the next slide, please. All right, so the next webinar with Steve is going to be Monday, November 17th. What happens after I record my lien and how do I get paid? So sign up for free at sunraynotice.com/education. We'd love to see you guys there. And then the next slide, please. If you don't mind, give us a moment of your time, give us some feedback. We really do appreciate it, and take it to heart of what we can do to better the content and what kind of information we're putting out there for you guys. So please give us that review. And then the next slide, if you don't mind. All right, and with that, that is all we have for you guys today. Thank you so much to everybody who attended. We hope to see you at our next webinar. Stephen, again, thank you. You're incredible. I really do appreciate you. I hope you all have a beautiful and wonderful sunny day. Thank you, everyone.